My guest for this hour, joining me from Los Angeles, California, is trial attorney Rachel Fiset. Rachel, great to see you. Thanks for being on the show, and Happy New Year.
Happy New Year to you, Michael.
All right, so let's start off by taking a look at the case. I want to begin, of course, at the beginning with opening statements. Want to get your thoughts on the state's opening. It was rather lengthy, but they had a very good story to tell and have a lot to work with.
The state is telling a story. I thought he was doing it effectively. They're going in chronological order. They're telling the lies. The lies will add up. They will add to what was he telling the lies for. I felt that he was compelling. The jury's paying attention. We have a note taker. I think that story will require a counter story. I'm sure we'll talk about that next, which is not something we saw, but we're going to have a factual case, and they're going to put on one fact after the other that I think they're just going to build and add up to a logical conclusion.
Yeah, this is a circumstantial case, obviously, but at the end of the day, I think there's so much circumstantial evidence. It almost qualifies for direct evidence. And you're exactly right. You thought ahead and you saw that I'm going to be asking you about the defense's opening statement. Yes, I agree with you. I thought I was looking for some kind of story, but the truth is, sometimes you just don't have a story, Rachel, and you go with what you got.
Right. The defense was making me wonder what the plea negotiations might have looked like in advance of the trial. Maybe there was just simply nothing there that they could grab onto, no leeway. But as she spoke, I just thought to myself, why are we here? I don't think she has much.
Exactly. I was thinking the same exact thing. But sometimes, prosecutors, they hold a strong line. They're not really offering very much. That's why these kinds of cases end up into court. So my question to you is, clearly the approach that the defense is taking is that, look, we're going to try to pick away at some of their evidence. Hopefully there's not enough there. We can poke enough holes that circumstantially you don't find my client guilty. But is there any other thing that they can hold on to here as a defense of this particular defendant?
Well, I think where she was headed was, hey, you're going to find out that he was lying and that he told these lies. And it looks like that's going to be completely inescapable. We might even admit it. Yeah, he was lying. Probably because he told various people different things. So some of those are lies. So she's going to get there. Like we have to eat the lying. But where she, I think, is going to have a really hard time at the end of that, if she is going to just kind of forfeit that he was lying, is the question as to why he was lying. And that, I think, is going to be the giant hole that she's going to have a really hard time getting around, even if saying, hey, circumstantially, that's all they have. There's not enough evidence to convict of murder. All you have are a bunch of lies. I think it's going to be very difficult to get around why he would have continued to lie and how the lies add up through time.
Yeah, and the other thing about the lies too, Rachel, is that, as I thought about this case, I said, who could kill their parents and do what this guy did? Maybe there's some mental issues there. Obviously he exhibited some other weird behaviors, but when you talk about the lies, they were so calculated and gone on for so long, that almost vitiates any idea that you could argue that there was a mental issue here, some sort of insanity, because he very clearly was planning this thing out and planning out his cover-up, and that ended up getting him caught. All right, Rachel, stand by.